Hi, Alicia Daniel Hall, owner of Genesis Law PA, and it's time for Ask an Attorney. One question I get pretty often in the probate world is, if there's a will, why do I need probate? And I think that's a really good question, and it comes from the fact that people don't understand what probate is versus what a will is. So let's make it very simple. A will directs how the assets are going to be distributed and who is going to be in charge of administering those wishes that were set forth in the will. And it all gets done in probate court. So basically, your will is the action plan for what's going to happen in your probate case. I see it all the time where someone thinks, oh, mom left the house to me in the will, so it's mine. No, it's not yours until you actually go through probate if it's going to be transferred by the will. So let's talk about the kinds of property that is going to have to go through probate. In a nutshell, property that is owned by the decedent on their own, so they're the only person on the deed, for example, then you have to go through probate in order to transfer title. Property that's going to transfer by operation of law or by contract will not go through probate. So some examples of those are life insurance policies. Those do not go through probate as long as there is a named beneficiary and that beneficiary is still alive. Sometimes the beneficiaries pass away and people fail to update their documentation. Now, each policy is different, and the policy will have language that states what happens if the beneficiary passes away before the decedent. There's usually a time period. So if they've passed away, let's say, for example, more than 90 days before the decedent, then the gift lapses and it's going to now go directly to the estate. Well, that means you have to probate the life insurance now. Another example would be, let's take a house that is owned by two individuals together, husband and wife. When the first one passes away, the latter, who is actually the survivor, is going to own 100%. That's easy. But what happens if you have a home that's owned by a brother and sister? Depending on how the deed is written, you could have one of two things. You could have it being 50-50 still, which means 50% is now going to the beneficiaries of the decedent's estate, and the decedent is the person who's passed away, with the other 50% remaining as being owned by whomever the sibling is that's still alive. So you have 50-50. On the other hand, if there is right of survivorship language in that deed, then it's going to transfer very similar to what happens with the husband and wife. Upon the death of the first person, the survivor will now own 100%. So, why do you need to go through probate if there's a will? Short and sweet answer is because the will dictates what is going to happen in the probate case. Thank you.